by the chairman of the Basic Law Drafting Committee when he introduced the draft of the proposed Basic Law to National People's Congress in April 1990. And in Cantonese is 互相制衡，互相配合。This is a relationship of regulation and coordination. And then with the judiciary, it is reserved the same constitutional position as pre-97, and it is to exercise its judicial power in the adjudication of cases independently. Right? 独立, independently. So that's sort of a broad picture of these organs of government in Hong Kong SAR and their relationship among themselves. And in order to give effect and reflect their proper relationship, there are provisions in the Basic Law which are stipulated for that purpose. We're going to go through some of them. So first of all, the judicial power first. Why and how independent? You're given these articles there. These are to preserve the common law system in Hong Kong. I'm not going to repeat them, but when you did your legal system, when you did your legal system subject, I think we covered that there. Cover some of this, the concept of independence, and how is that how is the independence being preserved? Concepts like security of tenure, concepts like, or rather specific provisions in the Basic Law regarding the appointment. The appointment of the judge has to be by the CE in accordance with recommendations made by an independent commission. And in Hong Kong law, we have the JORC, the Judicial Officers Recommendation Commission. That's something we covered before. And this is quite different from the PRC legal system. And we say, and we explain to you in the course of our lectures that because of this, even despite the fact that this is one country, judges on mainland China they do not have a role at all in the Hong Kong judiciary system. And indeed, as I had explained earlier, the concept of independence of judiciary on the mainland in PRC legal system is quite different from that in common law that is being practiced in Hong Kong. One significant difference in concept and is that judges in the common law system are given the constitutional role to interpret legislation and give effect to the legislation in accordance with such interpretation. Judges on the mainland in the PRC legal system do not have the power to interpret the law. They are given the responsibility to implement the law. Now, these are respective roles expressed in accordance with the basic ideology, the basic principles, but in practice, you can just flag it up, and if you like, you can do more reading about it. Just a matter of logic. When you say a mainland judge can only implement the law, if you ask the question how to implement the law, if the judge doesn't make a sense out of the law, that must be interpretation. Any words written is subject to our understanding of its meaning. And that understanding is a process of interpretation. So when you say that judges on the mainland do not interpret the law, it may be correct only as a matter of principle, but in actual fact, if the wording, unless the words used are so clear, the mental process of finding out the actual meaning is unnecessary, then it will be a strict interpretation. And if that's the case in common law, then the same applies. The same applies, right? So do that better in mind. But as far as for the purpose of this course is concerned, you don't have to bother yourself with those differences. What you need to know is that judges are independent in the common law system, and which is being preserved in the Hong Kong Basic Law, and that is how they are expected to perform their function. And this independent power goes to the full extent of having the power to adjudicate give final adjudication as exercised by the Court of Final Appeal. We say that in other autonomous areas around the world, the power of final adjudication normally rests with national courts. But in our case here, it is come within the Hong Kong judiciary. But having said that, do not forget that if a case involves an interpretation of the Basic Law, the final power of interpretation lies with the Standing Committee of the National People's Congress. Now, 2 points you have to remember. One, the final power of interpretation of the Basic Law is not with the CFA. It's not with the CFA, right? Two, it is not with the MPC. MPC doesn't have the power to interpret law. It is only the Standing Committee which has the power, given by the Chinese Constitution, PRC Constitution, Article 67.4. You don't have to remember the number, but it is the constitutional power given to the Standing Committee, which of course is out of necessity. MPC doesn't meet. I mean, doesn't meet. The MPC only meets once a year, so you can't really, it would be impracticable to give that power to MPC. All right. So that's for the judiciary. CE, the CE. I just highlight some of these powers for you, you should remember how I described the entire system. And sometimes if you were only asked to look at the 3 organs of power, we will include the CE's power as part of the executive power, 行政, the executive power. But these are powers these powers set out on the slide are powers only given to the CE personally. First, the power to appoint or remove holders of public office. Second, the power to refuse to sign bills passed by LegCo. Thirdly, power to dissolve LegCo. Fourthly, power to refuse to give written consent to bills introduced by members of LegCo under Article 74 of the Basic Law. Power to dissolve LegCo. Do you know how that power is regulated? Under what situation can the CE dissolve LegCo? Sorry. CE will not approve the bill. That, yes, that's how it will all started. When LegCo pass a bill, that bill will have to be submitted to the Chief Executive for signature and promulgation under Article 75 of the Basic Law. And but the CE may refuse to sign it if he thought that it's not compatible with the overall interest of the Hong Kong SAR. If he took that view, that bill will be returned to Legislative Council for reconsideration. Legislative Council, if by reconsideration pass the same bill by a 2/3 majority, then the CE will have 1 month to decide whether to sign or not. If CE still refuses to sign, then under Article 50 of the Basic Law, he's obliged to seek conciliation. If that fails, he is required to consult the Executive Council and decide whether to dissolve LegCo, put an end to his term. And should that happen, an election of LegCo will have to take place. The same may happen if the bill, if LegCo refuses to pass the budget of LegCo, of the government, or refuses to pass an important bill, then the process that I just described about consultation, conciliation, and so on can take place, so that CE may dissolve LegCo. This is provided in Article 50 of the Basic Law. So CE is quite powerful. However, CE within his 5 years term can only exercise the power once. Should the same situation happen the second time, what can CE do? Resign. He has to resign. He must resign. All right? So that, we say, is how the Basic Law provides a mechanism so that there could be mutual recognition and coordination. This is the way Chinese Express describe it. Under the common law, you may describe it as a kind of check and balance. And you will not forget, of course, not too long ago, Carrie Lam, CE, said there's actually no separation of power in Hong Kong under the Basic Law. She may be right, but she cannot say what I just described is not in the Basic Law. And indeed, the Basic Law, nowhere in the Basic Law uses the expression separation of power. And she's right to that extent. Right? But the Basic Law does maintain the common law, right, under Article 8. And the common law and separation of power is the cornerstone of the common law. Right? But Article 8 does say the common law so maintained cannot be in contravention with the Basic Law. So where are we? It doesn't matter, as long as we know where the provisions are and how they should be, how they should work. But to be honest, these provisions are not meant, are only put there, if I may say, as a reserve position. Hopefully, Hong Kong would never need to invoke those. Because once we get to invoking all those, we are talking about what normally called instability, which will not be in the interest of Hong Kong, so a lot of people believe, right? The next slide is what I just said, separation of powers. So we still believe this is not a wrong, not inaccurate way of describing the relationship. But I would suggest that this would facilitate us to understand what actually is the relationship, rather than simply relying on the label. To me, separation of power is just a label. What is important are how the provisions operate. How the operations operate. I mean, and in any event, we all know one would be very difficult, if not impossible, to find a pure or separation of power in the purest in the purest sense can operate. In the judgment rendered by now our Chief Justice, not too long ago, about maybe less than 10 years ago, and he basically bring out the point that the separation of power concept in Hong Kong, SAR, is not a purist. We're not talking about separation of power in the purest form. We really have to look at the substance rather than the label. So I think it's just a but a reflection of what Hong Kong is and what Hong Kong people normally are. I mean, being pragmatic. If we talk about legal theories and constitution theories, fine, it's very interesting. But what people are really going after is, are more concerned about is what actually is the effect on individuals. Normally, it doesn't, no direct impact on us as a citizen. And in Leung Kok Hong's case, the Court of Final Appeal make it made it in no uncertain terms that is constitutional separation of powers. Constitutional separation of powers, right? These are all public record and what the courts have said. I don't know whether they might, the judges might adjust their position or their views in the future. But as far as today, that is one of the, in fact, quite a number of cases you find judges describing the system in similar terms. Central government, though, represented by here 2015 when Zhang Xiaoming was the director of the liaison office, making public speeches, of course, will be understood to be reflecting the views of central government, emphasize the executive-led nature of the political structure, and he described this check and balance rather than separation of power. So check and balance seem to be the if you like, the common ground, right? And also independence of the judiciary is also the common ground. The next slide is for demonstrating the separation of power. First is CE cannot make laws because that is the legislative power, and that was said in the case of Leung Kok Hong in 2006. That concerned the secret surveillance powers exercised by law enforcement agencies. And before that case, CE had made some regulations, but that was considered not by way of law, which is required by the basic law. So government was given time to make the necessary law in order to regulate law enforcement agencies in their surveillance for the purpose of criminal investigation. Second, the CE cannot decide prison sentences because that is court's power. The case Yao Kong Man concerned about the remission power, it was previously considered as a power that can be exercised by the executive, but that case put it right that it should be the court's power. And then the last one about internal workings. This is a case 2014. Is about filibustering. Heard that expression, filibustering? Filibustering? No? Yes? Libel. Yes? It's filibustering. Right? Libel. So that's when some legislators kept on making their speech and with the purpose of unnecessarily lengthen the proceedings, try to delay. That case happened actually in year 2012, in May 2012, and when LegCo was considering the Legislative Council Amendment Bill, which dealt with the resignation of legislators. I don't know whether you remember that. 5 legislators resigned at the same time, and that triggered a by-election. And these 5 legislators came from the 5 geographical constituencies. So it became a Hong Kong-wide by-election, and that was considered as equal, as the same as a referendum. I don't know whether you remember the expression, 五區公投. No? Some say yes, and some say no, right? Maybe you are very young then. Yeah. 2012. Oh, that's nearly 10 years ago. Yes, indeed, 9 years ago. Yeah. We have Wong Yuk Man, we have Wong Yuk Man, who else? 梁家傑啦，陳淑莊啦，and then a few others. Yeah, they resigned from the various. Yeah. Okay. I remember this very well because I was then working in LegCo, so all this came back. Right, and then checks and balance. These are examples. The power of executive to introduce the budget, Article 62(4), balanced by the need for LegCo approval. This is a very important power, and also the power given to the 2 organs, respectively, are really a reflection of the common law constitutional principle. Same in UK, where if government needs any money for performing governmental service, that money they can only dip their hands into the kitty, into the treasury, if Legislative Council approves. That is a check and balance. So we say that the Legislative Council's power is a kind of negative power. It's a kind of negative power, and that actually has become a ground for arresting these 47 persons for this 35 plus objective. I don't know whether you understand what I'm talking about. This is the national security law. You read about the arrest of 47 people who organized a primary election as part of the strategy to achieve 35 plus legislators, so that, and they say, so that they can veto, they can vote down everything, including the budget. Once the budget is voted down, it will mean government not able to have the resources to continue performing governmental services like hospital, transportation, and so on and so forth, that it will be paralyzed. So I think it's one of the bases that this conduct was considered to fall within one of the offenses covered by the national security law. Right? But this is still ongoing process. I mean, it's just the process. I think the case will have eventually will have to go to court for trial and for decision. Second point here, power of executive to introduce motion on revenue and spending as provided under Article 4810, and that also balanced by the need for LegCo to approve. Same spirit, same spirit. Lastly, not lastly, but another example is power to summon, and that is governed, balanced by CE's power to decide if government officials should or should not testify. Investigations done by LegCo there have been quite popular way of holding government to account until 2009. Last one was I think about 2010 thereabout. Thereafter, we don't see any LegCo investigations. Some important one, the most probably, it's good time, appropriate time to mention that one. LegCo investigation on SARS. SARS, you know SARS? That was 2003. 2003, and LegCo set up a select committee, and with the aim to investigate how government handled that incident. In particular, how Mr. Tung, at the time, as chief executive, chaired a steering committee on the control on the fight against SARS at the time. I got a lot of stories to tell, but not tonight. I was legal advisor to that committee. Yeah. So LegCo may also conduct investigation. This is provided under the Basic Law 7310, and under Section 17 of the LegCo Powers and Privileges Ordinance, it will be a criminal offence if a government official or anybody ordered to attend refuses to do so, and except for government officials who are prevented of being stopped by the CE, but this has never happened. This has never happened so far. All right, and I'll move on to the next one about this is relationship between the CE and the LegCo again, and here we are trying to contain the LegCo. I mean, Basic Law try to contain the power, try to regulate the CE. CE actually has the powers, if you like, is very powerful, and that's why the Basic Law, the drafting committee, make it a point, is a very important point, to check its power. So that's the impeachment mechanism. I won't go through this now because I have gone through this with you earlier on. Okay. Let's look at how LegCo exercises its power. LegCo, under Article 66, jot it down, I should have brought up that. It was created as the legislature of Hong Kong SAR. It is the legislature of Hong Kong SAR. Legislature in Chinese is 立法機關，立法機關 is a 機關, it is part of government. this is again the use of words. In English, sometimes you say, this is government with a big G. That is government with a small g. What does that mean? Government in the big G would be the executive authorities, is specific to it. Jing Fu. Government in the small g is generically in the broad sense, and it includes legislature, executive, and the judiciary. Right? So that is how, and in Chinese it's difficult to sort of find a parallel usage. You don't say 政府 with what? No, 政府 is 政府, then we always relate that to the administrative part, the 行政當局 as 政府. Actually, 政府 could be as broad as including 立法當局, 司法機關, 司法機構. So these are very, so when you sometimes people argue about this and that, you really have to know, and you argue over description, proper description, proper expressions used to describe a certain body. Make sure that you know the exact context that you are discussing or arguing. Otherwise, you will be arguing cross purposes, and which is meaningless. Right, lawmaking. Article 66 created LegCo as the lawmaking body, and 73 set out those powers and functions. The powers and functions, in technical terms, we say is by way of enumeration, i.e. by listing. That is to say, under Article 73, there are 10 items, and this Legislative Council power and function is restricted to only those 10 items. Anything outside that will be beyond the power, ultra vires. And when you go to Article 73, interestingly, some of the provisions actually overlap. And but we don't want to spend too much time going through those. But the main function, of course, is the making of law. The making of law is described as the enactment, amendment, and repeal of laws. Now, this power is a limited power, we say, because it says this power has to be exercised in accordance with provisions of this law, means the basic law, and legal procedure. So this is a power which is 有限度, which has a condition. And so in accordance with the provisions of this law, it means, for example, if you're talking about defense, national defense, then it's outside you. However, with national security, Basic Law, Article 23, make it clear that Hong Kong SAR should, on its own, make laws on secession, subversion, national secret, association with foreign political powers, and so on. So that is a specific delegation to Hong Kong for making those. And Hong Kong, of course, according to NBC decision, has failed to deliver until and therefore found it, NBC found it necessary for it to make the NSL. As far as laws are concerned, there are different types of law, the ordinances and the subsidiary legislation. As far as subsidiary legislation is concerned, CE has been delegated with a lot of those powers. Going back to what I described about the anti-mask law, where Carrie Lam, the CE, said it was not because Hong Kong was in a state of emergency. What it was, I said I forgot, it was public danger. Public danger at the time. That was in October 2019. October 2019, when Chief Executive made those laws, the anti-mask law. And she said it was because Hong Kong was in public danger. And so these are the different types of law. And remember, I mentioned to you that CE has that power to dissolve LegCo. For dissolving LegCo, do remember there are set steps that he must follow. He must follow. So do pay attention to this. Article 50, that's where the power lies, but the story will start. Actually, the stories can start at Article 73 for LegCo to have made the law. And then, having made the law, under Article 75, it has to be given to CE to sign. It's actually 76, right? 76. CE signing and promulgation is Article 76. And when it's given to him, then you turn to Article 49, and this is where it provides that CE may refuse to sign the bill. And he's actually, there's no, the time frame. He can't hold the bill forever. He has to do it actually within 3 months. Within 3 months. And second time it is passed, same bill, he's only given one month. Right? But go to 49, then you should know the detail. And then another situation is where CE refuses to pass a budget. Now the word or the expression budget could be or requires some explanation, because in Hong Kong we actually do not have a procedure of passing a budget. What we have is the procedure of passing an appropriation bill. Appropriation bill. Now, budget would connote the both expenditure and income. That is the budget, right? 財政預算. The 預算 is how much you need to spend and how much you are going to collect. But in Hong Kong, there's no such one document which is called the budget. In Hong Kong, we have the appropriation bill, which is 撥款條例草案. 撥款 means is Chinese translation of appropriation. Right? This is where are we now? We are now April. Oh yes, government has introduced that bill now. It's being considered in LegCo. It will be passed, and once it's passed, then government can then dip its hands into the pot, the money pot, and which is kept by the Treasury. Treasury, you know the Treasury, right? And there are a lot of procedure involved anyway. They can spend money. How they collect money in Hong Kong is there are taxes, duties, and other charges. Now the tax and duty, they are governed by different ordinances. The Inland Revenue Ordinance, Stamp Duty Ordinance, Duty upon Commodities Ordinance, and so on and so forth. And if government wanted, and the government always have a steady income through these laws. The situation where it will involve LegCo is when they want to adjust this income level. It may be up or down. Right? Normally up, then they need passage. Right? Now, so there's no such single procedure of passing or not passing the budget. So it's very difficult. So what does Article 50 envisage? Is actually through study, through consensus between LegCo and the government, this budget, the word budget in Article 50, is considered to mean the appropriation bill, the annual appropriation bill. The annual appropriation bill. So that's about it. Important bill. There's no legal definition of important bill, nor is there a procedure to identify what is an important bill. So there's no, is in a way, is untested. Nobody knows what that actually should mean in reality. It's a concept that was borrowed from France. And in France, the government has to raise a flag and say, this is an important bill within the meaning of the Constitution. If you don't pass it, I'll resign. Or you will be dissolved. Right? A constitutional crisis will arise. So Hong Kong, as far as that Article 50 is concerned, so far, as I said, it has been examined in great detail, but so far we don't know. Nobody knows how it should work in reality when the situation arises, and everybody, I hope and I think, is hoping that it never need to resort to invoking that provision. But as a student, we have to know, right? And it actually underlies also highlight the very much Chinese philosophy. Right? It's only after, when there's no consensus after consultation. Don't forget this. This is not a hard power. This is some soft power to be used as well. Right? The CE is mandated, is required to undertake consultation in order to achieve consensus. Only if that fails. And even if that fails, he has to go to EXCO, Executive Council. Right? So you can see, this is a way to balance the two bodies. Right, and restrictions on the making of laws, I actually had mentioned this already. But perhaps 1, 2, and 3, there need to have a bit of adjustment. Article 74, when we look at it in the lecture, we know that LegCo members may introduce bills. However, these bills cannot relate to public expenditure, cannot relate to political structure, nor relate to operation of the government. So, in reality, it left very little room for a member or either individually or jointly to introduce a bill. And if the bill should relate to government policies, the introduction can only be done with the consent, written consent of the CE. So that signifies very much an executive-led government structure that the Basic Law has devised. Even if members are given the power, that power can only be exercised with CE's consent. Second point is restriction on voting in LegCo. The passage of government bills and motions will only require a simple majority of members present. However, in relation to a motion or a bill or an amendment to a bill introduced by a member, that requires split voting. Currently, there are only two groups in LegCo. One is a group 35 from geographical constituencies, the other 35 from functional constituencies. So there has to have simple majority from each of the two groups, which is much more difficult than simple majority of the entire membership. In future, or according to the latest amendment to this part of the Basic Law, is changed to also split voting for members' motions and amendments, but the two groups will be rearranged to one group, election committee, the other group will be geographical constituency and functional constituency. The election committee, there will be 40 of them. The election committee, the geographical constituency, 20, functional constituency, 30. Right, so this is what it will be like, what it will be the case after December. The 7th term of LegCo will be like that. Right? The last one is restriction allowing CE to return bills. The restriction there is that CE has to form a view that is incompatible with the overall interests of Hong Kong, and also he has got 3 months to do that. And if the bill is passed, the same original bill is passed with 2/3 majority, CE will be left with 1 month to decide. With 1 month. Good. Then the judges. Judges are appointed by CE on recommendation of independent commission. This is the JORC I mentioned. And who sits on them? We have the CJ, the SJ, 2 judges, 1 barrister, 1 solicitor, and 3 not connected with the practice of law. As far as the top judges are concerned, these are the judges on the Court of Final Appeal. Don't forget, this is the very unique court which has non-permanent judges who are invited from other common law jurisdictions. UK, Canada, Australia, New Zealand. These are top judges from their own jurisdiction. And their appointment has to be approved by LegCo and also reported to MPC Standing Committee. Can you remove a judge? Very difficult. Generally, they will be kept in their job until they retire or resign. And they can only be removed for inability to discharge his or her duties or for misbehavior. And ultimately, it's for the CE to remove them. And of course, she cannot choose who to remove, and she must follow the advice of a tribunal of at least 3 judges or 5 if the matter concerns the Chief Justice himself. This is under Article 89(1). All right. So the judges are given independent power to exercise the power of adjudication, including the final power. And it is only in relation to serious criminal cases where the jury, there's the jury system who decide the guilt or otherwise of an accused. All right. So in that sense, there's a little bit of, in order to complete the picture, if you like, for judges to exercise powers in relation to criminal cases before the court of first instance, they have jury. And you will see that among the 3 organs of power, the Basic Law makes quite a lot of provisions to govern to govern the way that their respective powers could be exercised, and also how the executive and the legislature interact, check and balance each other. But you find virtually no such provision in relation to the judiciary, which is quite understandable because of the important principle that the judiciary should be independent. All right? Okay. Let's move on to looking at JL, Judicial Review. And I explained this earlier about the nature of this, and I won't go over them with you now, and unless you have got any questions. The need to have standing, not anybody, not a busybody. This is not to entertain any busybody, but but someone whose interest has been substantially affected by a decision or an act of a body which is subject to judicial review. This body, generally, it is the government, but it also includes other bodies which performs public functions. Hospital authority, for example, or other bodies. There are many which is subject to judicial review. University. I recently represent Chinese Temple Committee. Chinese Temple Committee? Heard that? 華人廟宇委員會. And that actually is the body set up by law to oversee, to regulate the management and finances of Chinese temples. The 車公廟, the 黃大仙, the 天后廟, and so on. The all these come under that, and yes, I was in this judicial review case representing the committee because somebody complained against that committee for having done something which affected her rights, and that was in relation to 竹林禪院. You know 竹林禪院? 唔識啊? Okay. All right. And who can bring JR? Of course, there are two known figures whose names appear in a lot of JR cases. 梁國雄,梁國雄啦. Another one? 長洲覆核王. And that's Mr. Kwong, Mr. Kwok, Kwok Ji-kin. I fought against him in one of those JR cases. Yeah. JR, being called JR, C.Y. Leung, saying that he took an oath of office, omitting to say 香港特別行政區, 香港, only say 特別行政區. So the oath was invalid, he said, and therefore C.Y. Leung cannot become CE. But he only took out this application 440 something days after C.Y. Leung has already been in office, because it was after the legislative oath cases that he suddenly gave him the idea that, oh, C.Y. Leung didn't do it properly. In fact, he did not do it properly. He actually had omitted to say those words at the particular point. But we argue that that's de minimis. He didn't intend. It's de minimis. De minimis, 即係微不足道. And everybody, when hearing and watching him, saw that he was taking it solemnly in accordance with law. So that is not something that should go to the validity of it. But his arguments include saying that even Obama, when he took the oath, because he didn't take it properly, every word of it, he had to take it the second time. Yeah. But of course, the court did not accept that argument. Not to mention that it's a U.S. system, not Hong Kong system, right? But on here, you must also, I should remind you that Article 104 is an important article. Article 104. This is where you should know, in our context, it is an article which the Standing Committee of the National People's Congress had given it an interpretation. Remember, there was an interpretation that the Standing Committee gave in the middle of a trial, in the middle of a JR trial in Hong Kong, which was unprecedented, and of course, never again, not yet again. That was a situation where I was in court representing government, and suddenly after we had been in court for 2 days and heard that, hey, standing committee is going to come up with an interpretation. Now, that makes it very difficult or makes it more complicated for those involved in the proceedings. Because whatever the standing committee decided as a matter of interpretation becomes part of the Hong Kong law. Then, without knowing what they are going to interpret, what is in the interpretation, you then don't know what you are putting forward would be the law, would still be the law. And fortunately, in a way, I mean, when it came out, and the court invited us to make a further submission, and our conclusion was it actually has the same effect as what we had argued in accordance with the common law. So all the requirement about sincerity, formality, and so on, and inform, are all there actually under the common law. And thanks to Leung Kok-hung, because in 2000, I can't remember which year was it, but quite a few years ago, the first time the case went to court because of the taking of oath was Leung Kok-hung. And it was not the case did not draw much attention, but the court at that time already, Mr. Justice Hartman, he already made it very clear what actually under the common law is required of the person who takes the oath under the Oath and Declarations Ordinance. And all this is consistent. So back to, without going into too much details, do remember Article 104, and do remember what is required of the oath taker. And don't forget, 104 applies not only to LegCo member, but to all important officials in Hong Kong, from CE to start, public officers, public officials, and also principal officials, and also judges. Right. So, and indeed, the interpretation given by the Standing Committee was not directed at the LegCo member. It was a general interpretation. General interpretation. Yeah, I mentioned all this already. When will judicial review succeed? I briefly mentioned this earlier when explaining what is JR, and these are the conventional grounds: illegality, irrationality, procedural impropriety, and I will leave this to you, constitutional review. This is what we mentioned already, so I'm not going to repeat this. Rather, on interpretation as a subject, to underscore the very important arrangement that under the Chinese Constitution, it is only the Standing Committee that can interpret Hong Kong Basic Law. And the power that is given to the Standing Committee is both general and unqualified. General and unqualified, this is a phrase that you have to remember, because these are the words used by the Court of Final Appeal. General means everything. Unqualified means no restriction, no condition. This is in accord with the constitutional arrangement in PRC. MPC is the supreme organ of power. No institution is more powerful than the MPC, so as the Standing Committee. So as its Standing Committee. And not to mention that Hong Kong courts are but courts of an SAR, and is given a high degree of autonomy only in relation to matters that come within that the courts have the jurisdiction to adjudicate, not everything, anything. So these are the interpretations that have been given by Standing Committee, and I think these will be useful to illustrate how the Standing Committee exercise the power. These occasions illustrate that, for example, 1999, it was on the instigation or invitation of the Hong Kong SAR government through the State Council that Standing Committee made the interpretation. The interpretation given in 2004 and 5, these were made on Standing Committee's own initiative. 2011, it was a request made by the Court of Final Appeal in accordance with Article 1583, where because the case can only be concluded upon the proper interpretation of the basic law, and the condition and the provision of the basic law concern the relationship between the Hong Kong government, Hong Kong SAR, and central authorities that come squarely within 1583, and therefore the Court of Final Appeal, although by a majority decision, did request the Standing Committee to give an interpretation. And then 2016, that's the one on the oath case. And that was again on the Standing Committee's own initiative. Human rights, always an important subject for our course. When you look at the past exam papers, I think you can find there's at least one, if not more, question on human rights. So if you wanted to find a topic for focusing, this may be one that it's worth spending time on. Constitutional documents protecting human rights in Hong Kong, there are these three documents: the Hong Kong Basic Law, the Bill of Rights Ordinance, and the ICCPR. Article 39.1 is the key provision, and it says the ICCPR as applied to Hong Kong. Now these are key words that you have to have, because not every provision in ICCPR applies. There have been reservations entered for Hong Kong, like immigration, like elections, and so on. These are reserved, right? Secondly, shall be implemented through laws of Hong Kong. So ICCPR does not apply directly. It has to be applied through laws of Hong Kong. And in the case of Hong Kong now, we have Hong Kong Bill of Rights Ordinance, which was intended for implementing the ICCPR. And that's why when you look at the Hong Kong Bill of Rights Ordinance, Chapter 383, you find that there is a Hong Kong Bill of Rights. The provisions, the wording, basically not exactly the same, but basically very, very similar, very close to ICCPR wording. And because of that, the courts have treated the Hong Kong Bill of Rights Ordinance having some status, special status, as the ICCPR. 39.2 is important because it is which provides a basis for JR. And because it says the rights and freedoms enjoyed by Hong Kong residents shall not be restricted unless prescribed by law, and such restrictions shall not contravene the provisions of the preceding paragraph of this article. Now, your assignment, you're right, when you wrote your assignment, I think you had already looked at that, and although I haven't finished marking the papers, I think most of the papers I marked, in fact, show quite clearly that you understood what this provision is intended to mean. Do not forget, when we are looking at this subject, you should also be aware of the individual provisions in the basic law that gives specific certain rights and freedoms, like freedom of assembly, freedom of speech, freedom of religion, and so on, in the basic law. Now, these appear to be overlapped, but at the same time, that was intended. And at this point, do not forget that the basic law, or for that matter, the basic law is not a piece of typical law. It has its political setting. This is really for one of the objectives of having the basic law was to give assurance to Hong Kong people about human rights. So the drafting of it tend to give you more than absolutely necessary. So these are the protection of human rights aspects. 39.2 makes clear that most of these rights can be restricted, but not torture, of course. And they have to pass different tests. And you are able, many of you realize 39.2 actually is set out in two parts. One, the first part is on the prescribed by law requirement, which is looking for legality, the legal basis of that. And if a law, if there's no express grounds that certain rights can be restricted, the court nowadays applies the proportionality test to review whether they might infringe those protections. I shan't repeat them here because, to be honest, you should all know this. This is proportionality. Okay. That's it. That's right. And I want to leave at least 5 minutes or so for you to ask any questions, actually. Are there any questions? Luckily, the part that I rushed through concerned very much your assignment, so which I thought is okay. So, are there any questions? Yeah. Proportionality test. Yeah. Very similar. How can you differentiate legitimate? To a situation, yeah, to a law, right? Legitimate test is actually the first step of the proportionality test. You have to identify a purpose which is legitimate, and then you look at the measure, the restriction, to see if it's rationally connected with it. So, and then you look at if there's a rational connection, then you look at the minimum impairment and say, well, is a restriction? Are there restrictions which is less restricted? That's a three-part test. And the fourth test is whether ultimately it requires too much burden on the citizen. like if you want to do anti-mask law, the legitimate purpose is what? Is to prevent people from having the emboldenment effect arising from wearing a mask. Because there's expert evidence that, and indeed the judge said, it doesn't need expert. Everybody knows when you wear a mask in a public place, you tend to be bolder. It's called an emboldenment test, emboldenment effect. You may do things that you would not do without a mask, right? And it is in the context of the public danger because of public possession, peaceful possession turning violent. One of the causes is the emboldenment effect. So that's the purpose. Peace, order and peace, legitimate. Rational connection, yes, because it was considered that, accepted that there's an emboldenment effect. Is there least impairment? Is there other way to prevent the emboldenment effect? No, because what else? I mean, there was one concern that those who wear masks was to exercise his freedom of expression without reviewing his or her own identity, because there may be people like an employer, and they cite the example of Cathay Pacific and say, Cathay Pacific may take it on the employee who went on these protests. So there's no other way to protect the freedom of expression. We argue that, well, you can actually. There are other means to conceal your identity, not necessarily wearing a mask. You can do other things. So itself doesn't, is not a therefore it's a minimum impairment. There's no other means, because you have to weigh against the consequence. The consequence is violence, and people get injured, and property got damaged. And the court did not actually need to go to the fourth test. It's so obvious. Indeed, when you go to Hyson's case, Mr. Justice Bukhari said it will be in very limited circumstances you need to go to the fourth test. Normally, if you are successful in passing the third test, that will be it. And but in the case of Hyson, it's a little bit different. It was concerned about the exercise of property right, about Hyson development in building their blocks, whether the height restriction was necessary and so on. So it's a different